I'm Kate Brady. I'm the Immigration Department Head at the Constitutional Law Center for Muslims in America, and I welcome you to this webinar, and we're going to be talking today about the Muslim ban, and sometimes we refer to that as Trump v. Hawaii. And this is a short seminar, so it is in no way intended to tell you every single thing you could ever want to know about the travel ban, but hopefully it will give you a little insight. And then also we're going to walk through the iteration of all of these travel bans, talk about the waiver process a little bit, and then give you a little peek behind the curtain at CLCMA and how some of the cases that maybe intersect a little bit with what we do here at the Law Center. So let's jump on in. All right, the current administration has always made it known that they are definitely not pro-immigrant. So a presidential proclamation based on an executive order that was intended to stop those individuals from coming into the country who they said were a national security concern, either through terrorism or public safety threats. They did this in a broad-based way. They invoked their authority under the president to place a 90-day travel restriction to the United States on those national security concerns for countries that were majority Muslim, which is why even though some people might call this a travel ban, most often in the industry we do call this a Muslim ban because that was the people who were affected were from the majority Muslim countries. There was a lawsuit right after this, and the lawsuit was successful. It blocked this iteration of the Muslim ban because the government could not show that the ban did not have that disparate impact for just reasons, which is a protected class. But of course, this government will not give up. So shortly thereafter, in March of 2017, was the Muslim ban 2.0. In this case, we dropped Iraq, but kept most of the other countries there, refugees and nationals. So instead of 7, we had 6. And of course, the lawsuits came. These cases were to win a preliminary injunction against the government in instituting the ban. But unfortunately, those cases were appealed by the government. The government did kind of have a partial win. They were able to institute the ban, except if there was not a bona fide relationship with a person or entity in the United States for that person trying to enter. So not having a total win, of course, they went right on, and we got Muslim ban 3.0. And this one, I guess to get a fact that they were being touted as anti-Muslim, they threw in some other countries. So now we threw in Chad, North Korea, and government officials of Venezuela. Obviously, North Korea and Venezuela have never been thought of as majority Muslim countries, so they thought that was enough. There were additional lawsuits, and I guess the Supreme Court agreed with them that this was an okay ban, and they were allowed to go into effect in June 26th of 2008, mostly because they had also added at this point a waiver process. But for those who have been trying to get into the United States under this ban, we'll tell you the waiver process is anything but fair and anything but a process. And we'll talk about that a little bit later. Chad, I guess they upped their game. They got their identity protocols in place and they were dropped. The next thing that happened was the government once again, about 1 month after this win, or at least a partial win, went up and tried to once again ban refugees. They did another resettlement ban, and this one is the most concerning to me because it actually had a wide variety of countries, again, mostly Muslim, and a long list. 120-day refugee ban was set to expire, so they, I guess, needed to extend it. And of course, a lawsuit. They lost on the same issue that they have lost on before, which is if there's a bona fide relationship in the US, you cannot ban these refugees. The reason why this is really disconcerting is because if you look at this list of countries, you may think it's a wide variety of countries, but it was very carefully selected. This set of countries represents 80% of the refugees that have entered the United States in the last 2 years. So what could not have been done legislatively is now being done administratively. The government very recently, in January of 2020, put even more countries on their target, and they added these 6 countries: Burma, Eritrea, Kyrgyzstan, Nigeria, Sudan, and Tanzania. These next couple slides will kind of show you how all of these bans work and how they go through each of the countries. And They're a little bit different, and it depends on when the ban was instituted, whether that was in June of 2018 or in January of 2020. There's things that will say on the date of the declaration, and you have to look at which country it is and when that ban for that country was instituted. So just as you go through, some countries it's immigrants and visitors. With Iran, it's pretty much everybody except students. This one concerns me because even though it says students aren't banned, in practicality, students who have been vetted, gotten their student visas, come to the United States, thought they were joining a program, the university was expecting them, maybe even for research, have been stopped and turned around. Most frequently, it's been at the Boston Logan Airport, and there are attorneys who are fighting against that because it is definitely not in conjunction with what has been agreed to in the lawsuits and what they said was going to happen when the court ordered them to have a waiver process and also to have this extreme vetting. Venezuela is the government officials. Somalia is also adding a total suspension of the diversity visa, which was not in any of the prior bans. That is also in some of the other countries, such as these four, and their exception is the special immigrants who have provided assistance to the US. Again, Sudan and Tanzania, it's on the diversity visa, and Yemen has both immigrant and diversity visa. That was amended a little bit here in 9983 because they were in some earlier iterations of the ban. But of course, when there's a rule, there's always exceptions. The one that seems maybe obvious is lawful permanent residence, and I would also note that US citizens are not banned under any of these presidential proclamations. They are already exempt just by the fact that they're US citizens. Again, this is kind of what I was talking about, the effective date for the applicable proclamation. So if you're already in the US, when your country's proclamation came into effect, you are not banned. Of course, you may have to explain that to the CBP or the visa officer. This is by the rule, you're an exception. Again, if you have a valid visa on the same applicable date, if you were having a visa and it was revoked or canceled by the earlier executive order in January of 2017, then for that, you are also an exception. Or if you'd been admitted or paroled to the US after the effective date of the proclamation, whichever one applies to your country, and if you have travel documents that allow you to enter the country. We go on. Then if you are a dual national, so if you're not quite familiar with this concept, somebody could actually be a national of two countries. So let's say you're a national of both Nigeria and another country that maybe is close by, let's say, that isn't on the list. So let's say Ghana. So maybe one of your parents was Nigerian and one of your parents was from Ghana. So you can travel to the US on your Ghana passport, but there are some other travel bans that are in effect on the COVID-19. So maybe not. But under this specific ban, you would have an exception. We have some diplomatic exceptions other than Venezuela, and people who've been granted asylum or coming to as a refugee, granted withholding of removal or protection under the Convention Against Torture, which most often we abbreviate as CAT. So this is kind of cool. This actually came in so timely just today, minutes before we were going to go on air and go live. This is a tool that you can use to determine if you are subject to any of the travel bans. It was done by the University of Pittsburgh Legal Clinic, and it's really awesome and really cool. I just kind of tested it out, and I chose one that I knew would be banned, and it came out saying I was banned. So that is really cool. If you want to go to it, you can see the website there. You can pause, you can write it down, and go out and see if that applies. All right, let's talk about this waiver process. Not much of a process, but we're going to talk about it. So when anyone goes to a visa appointment, and a visa is that travel document that you're going to get as a stamp in your passport, this is something that you will meet with the consular officer. They will have your application. You will have filled out your application online, paid your fees, and you're coming really to get them, maybe to have a little conversation if they want some more information. And they may ask you for additional documents. This is really the process that everybody goes through who needs to get any visa into the United States. That consular officer is going to determine whether you are eligible for the category. So let's say in a student's case, have they been admitted to school? Do they have the I-20 that notes that they have the proper process and they can be admitted into the United States in this category, or at least apply for admission with the visa? So that's the first one. Are you eligible? You pass through, are you eligible? Then you come through, are you exempt or an exception to the travel ban? And again, right now, it's a little bit of a misnomer that we're even doing this waiver process because all of the consulates and embassies have been shut down on the COVID-19 travel restrictions, which encourage you to go watch that webinar as well. But in a normal world, you would then be passed on to the are you an exception to the travel ban. And then as you go through that, if you're not an exception, are you eligible for the waiver? And in the waiver context, they're looking at if you are not allowed to come to the United States, would that be a hardship to you? Is the first part. And the second one is letting you come to the United States in the national interest of the US. And the third one is the one that most people get tripped up on, which is your entry would not be a threat to the national security. The reason why this is a big one is because when we're looking at the countries that are banned, those are countries where we have already determined that there is a national security risk, especially, I would say, for males from those countries. So it's a big issue if you're especially coming as a family group, as we'll see in a minute. In the waiver process, one of the reasons why it's the most frustrating is because there's no set time frame for a decision. And you can be at your appointment, think everything went well, and get the answer over a couple of days, and you look at your status, and instead of, approved, we'll give you back your passport, it'll say maybe that you're refused, or that you have a 221G, and they'll want more information, or you've been placed under administrative processing. And as we were talking about males, everybody is considered on their own merits, and so you may have a family group, husband, wife, and kids, and the mom and the kids might get granted, and the dad is left out because they feel like he is going to be a national security threat, which is in nobody's best interest of that family, then nobody's coming. There's also no process. So you don't get to submit it to the Department of State ahead of time. You can't submit it to the consular officer. Attorneys have tried to find ways around this, and basically the Department of State has said, your application is enough, we'll make a decision from there. But there's really no way to include that in your electronic application. And if you do get a denial and a negative decision, a consular officer's decision is non-reviewable. There are opportunities if your case has been pending much longer than it needs to be. You might be able to sue to get them to make a decision, but once a decision is made through the Department of State at the consular level, that's the end until you come back, reapply, and show why you would have a different circumstance, which is really difficult if the circumstance is 10 years ago, I was in the Army in my country because we were conscripted, and that's never going to be a circumstance that's going to change. All right, so let's move on. Let's talk now about how this intersects with what we at CLCMA do. I am the department head of the immigration section, and immigration is very broad. It can be deportation, it can be asylees, it can be people who are trying to get citizenship or maybe granted lawful permanent residence, and those are all general areas. And prior to coming to CLCMA, I actually did a lot of that, what we call petition-based immigration. I did a little bit of deportation several years ago, and just really a wide range of things. But what we do here is we do federal litigation in the federal district courts and in the appellate courts, and we've even had some cases that have gone to be filed with the Supreme Court. And what we're looking at are individual cases that will make an impact in the community. So travel ban litigation is often multiple agencies or law schools or law firms who are fighting a general fight against a hypothetical, these people are going to be harmed, but we take individual cases. And especially in the immigration context, we take individual immigrants who have a problem where their cases are either delayed or denied, or we can see on the horizon that things aren't going well. So as you may understand, immigration is very complex and broad, and the impact litigation that we do requires that we understand those general immigration, broad, complex concepts so we can identify the problems that are happening. The reality is that most immigration attorneys never litigate. That is a very subspecialty. And we take on these cases, we know that they're going to be very time intensive. So just to kind of give you a little peek behind how things happen, we receive several hundred intakes a year across our practice groups, and we have criminal, civil litigation, immigration, and then we also have a non-practice group that does some boot camps for organizations to give them some kind of a tips and tricks, and also will kind of do a review of their organization and help them to be in compliance so that they maybe don't have the issues that the government will want to talk about for why they're out of compliance and maybe avoid some of the litigation issues. So we get those, we take them in through our website, and then we do an internal consultation. We discuss it internally to recommend it to our CLCMA board, and that board votes. The cases that get through that process will become our impact litigation. They are very specific in subject matter. We look at cases that fight against discrimination and injustice in the United States government that have had constitutional or civil rights violations based on race, religion, or country of nationality, and most often that have complex facts and legal questions related to national security. In the immigration context, you might have heard of the review process that happens kind of behind the scenes at USCIS called CARP, and that is the one that we are most often caught up again when there is a delay or a denial in an immigration case. Again, like I said, something like somebody was a member of the military in their home country or other very specific issues, and we tend to look at those and decide whether or not we can make that recommendation to our board so our board can vote whether we can take that case, which means we do take fewer cases and we vigorously represent those few cases that we do. And you might be asking about what can we do for you if you're not in one of those areas, but I will assure you that every case in the immigration context will get to be heard for you to tell me your facts. Then we will discuss if you even need an attorney. And if you do, you're just coming to our organization with questions and wondering, is it just filling out forms? My relatives did theirs, the attorneys cost too much, that's why I'm coming to a nonprofit organization. Besides, my case is simple, which I can tell you until it's not. We have cases that very seriously should have come to an attorney many years ago because they may be in their second or third attempt at getting a benefit and they have been denied, and it's in civil rights and discriminatory ways for national security issues that had qualified attorney been involved, they might have been able to identify those and have a better solution prior to a denial or a delay. So I will give you tools to find that attorney that can do your general immigration case if it is not within our civil rights discrimination. And these are the typical resources I give, although a lot of times I will give you an email that is very specific to your location, because these each do have kind of a drill down where you can find your location. And that is something I think is a value add that I can do for you. So hopefully you don't see us necessarily as just a service that you can get a referral from, but also that you can have an opportunity to have your case heard and vetted out and to know what you can do and if you're on the right track. And I really do appreciate that you came here today to watch our webinar. Again, my name is Kate Brady. I'm the Immigration Department Head at the Constitutional Law Center for Muslims in America. And I thank you. If you do think that you have an application that is lingering in the immigration world that needs my attention, I would appreciate you submitting an inquiry. And also we have cases that are in the civil litigation and the criminal that we would also love to hear about. Cases such as maybe no-fly or watch lists that you can see some other webinars on. Those are the ones that maybe are travel ban related that we can talk to you about. But hopefully you'll watch the rest of our webinars. We have a wide variety throughout each of the departments, and we appreciate your time. Thank you.